Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I've got to say this, and now I've said it. I want to tell you that nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, in the course of this podcast over many years, we've discussed the delay, denial, and termination tactics that disability carriers use. Today, I'm going to revisit and expand on some of these strategies. And in doing so, I'm going to share with you some case examples that show how disability carriers will try anything to see what sticks if they believe it could lead to a successful claim denial or termination. So we're going to talk about three things today. Number one, should my ERISA disability attorney hire a vocational expert in my ERISA disability appeal? The vocational evaluation game. Number two, the sedentary work game that disability carriers will play at the any occupation stage of an ERISA disability claim. And lastly, Guardian's untimely production of new evidence used to deny a claim and what one court did about that. Let's take a break before we get started. And I look forward to having you come back with a pen and a pad so you can be taking some notes, because this information is timely regardless of how old your disability claim might be or how long you've been on claim. These games are the games that you may face in a claim denial or termination.
Have you been robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. Should my ERISA disability attorney hire a vocational expert in my ERISA disability appeal? Let's talk about the vocational evaluation game. Now, as a rule, I would say the answer to that question is yes. And that's particularly true if you are at the own occupation stage and the disability carrier or plan misclassifies your own occupation. That's really crucial because we've got to start out with a definition of disability in the terms of your disability policy or plan and what that definition of occupation might be. Remember, you have insured your occupation, not a job. And so it's really important that you understand, one, that definition, and then two, you understand the games that are played at the own occupation stage. Now, many times disability carriers will take the information that you have provided to them in your initial application material. Remember that work history form that you completed? They're going to take a look at that. They're going to contact your employer and they're going to get information from them about your occupational duties. That might be in the form of a job description, if you will. But more often than not, what I find is that they don't get the correct information, either because the employer isn't telling them the truth, or if they're using an occupational description from your employer, it's not necessarily accurate. Why is all of this important? Because, again, when we look at the definition of occupation, we need to understand whether it's your occupation as performed for your employer, performed in the local economy, performed in the national economy, or performed pursuant to the old outdated dictionary of occupational titles. It's important because they're going to be looking at what the physical requirements of your occupation would be, and then measure, if you will, based on what your physician has to say, whether you're able to go back to those occupational duties. Now, many times when they're trying to determine this, the vocational evaluator will be playing a role in this. What is a vocational evaluator? A vocational evaluator is an expert in the world of work, but in the context of an ERISA disability claim, they're basically liar for hires who are being asked to create a reason or reasons why you can do your own occupation. Now, they also play a role when the definition of disability changes from an inability to do your own occupation to an inability to do any occupation. What the VE is looking for at that point are transferable skills, skills that you've learned in your past work. For example, if you are a nurse, you have the ability to engage in patient care. You have the ability to listen. You have the ability to chart. You have the ability to do math. You have the ability to make informed decisions. And so, what they're looking for is to determine whether or not your physical or cognitive restrictions and limitations, as they determine them, will allow you to take your skills unimpeded to some other occupation. Or if there has been a reduction in your ability to take those transferable skills to another occupation, the extent of that. Now, the game here, obviously, at this stage is to prove that you can engage in at least sedentary work and that you've got skills that you could take to a sedentary type occupation. There are times, however, when the definition of disability also requires that any other work that they identify, other occupations they identify, have significant numbers in the local or national economy, or potentially that they pay a certain wage. And again, that's a different game for a different day. But if what has happened is typical, the VE will say that, hey, you have skills that you can take to other occupations by virtue of what our physicians have to say about your restrictions, limitations. And here are these jobs. And by the way, this is how much they pay or don't pay. Now, when that occurs, I, as an ERISA disability attorney, get a copy of the claims file, and I want to analyze it from beginning to end, looking for all the reasons to challenge a wrongful denial or termination. And one of the things it does involve is looking at these vocational reports prepared by the carrier or plan's in-house vocational evaluators. Clearly, they're often biased in favor of the carrier or the plan. So I want you to understand that this is a part of their toolbox of the denial tools, if you will. They will provide to the VE maybe a accurate summary of your medical records. They may provide them with a summary of the restrictions and limitations assigned by their peer review doctors. They'll never tell the VE what your physician's opinion was about your restrictions and limitations. And then, of course, they'll go about doing this vocational analysis. Part of it does require that they understand your former occupation so that they understand what skills you've learned in the course of your employment history. And again, that's a common mistake. Carriers will misclassify the occupation, and they'll do that through the VE, and they'll maintain that mistake through the entire claims denial or termination process. And again, at the any occupation stage, the VE is going to use some computer programs to determine your transferable skills, which you've learned in the past work that could be applied to other hypothetical situations. Once they've identified a number of occupations, and normally it's 3, they will do a labor market survey. Now, allegedly, this is done to determine what work is available either in the local economy or the national economy, depending on the terms of the policy, and they potentially will confirm job availability. They don't have to, and potentially they will confirm wages. And again, they don't have to, depending on the terms of the policy or the plan. But I want you to understand that these are just some of the tactics that they use, and these tactics can be rebutted. And if unchallenged, a judge is going to rely on the opinion of that vocational evaluator, regardless of how faulty it might be, regardless of how shaky the foundation might be, and regardless of how invalid the conclusions are in view of what your physician has to say about your abilities. What I do, of course, is to hire a vocational expert to counter all of the errors that I see in the vocational report. I'm not going to leave them unchallenged. And normally we will argue that the carrier has failed to properly determine your restrictions and limitations, both physically and cognitively. They've misclassified your occupation. They have performed an invalid transferable skills analysis. They haven't considered exertional and non-exertional issues in determining what skills you might have that could go to other work. They've done a faulty labor market survey. The wages that they have found are inaccurate and are not consistent with the terms of the policy. So you can see there's just a laundry list of ways to rebut these common mistakes. You can also understand that this is something that you can't do. You're not a vocational expert. And that's why at Cavey Law, we hire a vocational expert to take apart that faulty vocational evaluation report that is the basis of a claims denial or termination. Got it? Let's take a break.